So as we begin the August 2025 legal update, I just want to remind everybody, as I do at the beginning of every class, that in terms of a reliable source for staying on top of all the changes in the industry, I encourage you to take advantage of the resources that we offer here at LIBOR. In particular, every Thursday, you should get an email. If you don't get it already, please go ahead, sign up on our website, lirealtor.com. All the event information, news, industry news, and also a free weekly legal tip. And that's really the way that we here try to convey a lot of the updates, new changes in the law, in the industry to you. And we are dealing with a lot of changes. I will say the summer's been pretty quiet. There's a couple of new trends I'm going to let everybody in on. And I do try to update this course every month, but really the best way to stay on top of things, in addition to taking this class, which we offer free every month, is following the weekly legal tips, because that's the way that I get the information to you about changes that are happening. And we also have a lot of great events that I encourage you to attend. The big one coming up, our annual membership meeting and elections for directors, is coming up on Wednesday, September 10th. It's on Zoom. It includes 2 hours of free CE. 1 hour is going to be me and Al Fazio, who's another attorney who works with us in our legal support center. Al's great. He's a fantastic attorney, really knowledgeable, entertaining as well. And he and I are going to go through some of the kind of more commonly asked questions, some of the trends he's seeing in terms of questions that have been submitted to the Legal Support Center. So it'll be a little different than the course you're going to get here today. And we also have Dr. Lawrence Yoon and Nadia Evangelou from NAR. Dr. Yoon is the chief economist for NAR, and they're going to talk about the real estate market outlook nationally. Just a lot of great information, I think, that will inform you of kind of what's possibly to come, or what's expected to come, but also information that you can pass along to customers and clients. So it really should be a great program. I encourage you to sign up for that if you haven't already. Again, it's free. It's on Zoom. In addition, there'll be an update about things happening in the association. And also, you can vote for your directors. We have, a lot of people running for the LIBOR Board of Directors this year. So get out and vote on the 10th, and certainly come to the meeting as well. Also, make sure you go to our website frequently. It's updated every day with new information, lirealtor.com. Not only the legal tips, our documents on demand, our dispute resolution center. I always like to mention this because we have a really good program called the Ombudsman Program that members have taken advantage of. And I would encourage you, if you've got an issue, doesn't have to be a full-fledged dispute, but a problem with another realtor. It could be on a transaction. You're just having a communication gap. You're not looking to file a code of ethics complaint. You may feel that someone's not doing something the right way. You've already talked to your broker, and you just need a third party to kind of put the heads together and get through whatever the issue is. Call our professional standards department. We have this free ombudsman program. It's highly successful. Consumers can use it too, but realtor to realtor is certainly something that these ombudsmen, they are realtors who are trained in really dispute resolution tactics. They can resolve disputes before they become a problem. So before you have to file that arbitration request or ethics complaint, consider calling the professional standards department, ask for an ombudsman. It's a free program. It's just basically over the phone, and they can try to resolve your issue before it becomes a bigger problem. Lastly, I mentioned the Legal Support Center. In addition to the NYSAR Legal Helpline, which is available to all of you as NYSAR members, LIBOR also has its own legal support center. It's available 9 to 5 Monday through Friday. You can access it by calling extension 335 off of the main LIBOR number, which is 631-661-4800. The attorney who answers the calls is not your attorney, can't provide you specific legal advice, but certainly can provide you information about legal issues, where to find certain things, what the law is on a particular subject. I see the reports in terms of what people are calling about, and it is a really helpful service. So if you are again, having a question that you need some help with or need to be pointed in the right direction, please take advantage of that benefit. So I mentioned I get a summary every month of what the questions are that come into the Legal Support Center. I also work with the Legal Support Center on a regular basis to help answer some of the questions that all of you have been asking. So here's kind of a sampling of what's come in the last month, and I like to update this every month with some issues that seem to be popping up more frequently. We have been asked a couple times, is cold calling finally allowed again in New York? The answer is unfortunately no. It is not allowed yet by law. At this time, it's still prohibited. Believe it or not, we're still in a state of emergency here in New York. We've been under basically a perpetual one for various reasons since BC, before COVID, or just after COVID, I'll say. There is a law in New York that says it's unlawful to make any telemarketer, this is not just real estate, to make unsolicited telemarketing calls to members of the public during a declared state of emergency. We are still under one. It has to do with the situation in New York State correctional facilities. It remains in effect until at least August 28th. It could be extended again. What typically happens is the governor extends these month to month to month. But if this one does expire, I can assure you, you will get a notice from us. I'm sure you'll get a notice from NYSAR as well, letting you know that cold calls are finally allowed again in New York. And also what the process, there are some changes legally in terms of the steps you need to take when you do make cold calls. And we will provide an update on that at the time. So stay tuned. Hopefully the end of this month, this is the last extension of this current state of emergency. We don't have any more, but unfortunately, the answer right now is cold calling is not allowed. As I've said in the past, any other kind of marketing is allowed. You can think of anything else you want. It's allowed. It's just unsolicited, meaning cold phone calls and text messages are not allowed. My slide got a little bit messed up here. So this is a question that comes up a lot about the property condition disclosure statement. My seller's a trust. Does the trustee need to complete the property condition disclosure statement? No, there are exemptions as far as when you need to provide a property condition disclosure statement to a seller and when the seller needs to provide it to the buyer. Those exemptions include vacant land, condos and co-ops, as well as transfers by a trustee. So a bunch of other exclusions. There's 14 of them total. Includes transfers under a court order or pursuant to a foreclosure sale, any kind of trust or estate administration. So an administrator of an estate, an executor, new construction, number of exemptions. I will say if you have any questions about whether the seller needs to complete it, though, you should have the seller speak to an attorney. It can be a legal determination, but the basic ones here. So if you have an estate, you have a trust, they do not need to provide a property condition disclosure statement. Looking at the chat, I see Christine has a question about cold calling and can we make calls to invite folks to an event? If you have a pre-existing business relationship with them, yes, I think that would be fine. But calling up people who you don't have any relationship with, you don't have any current business with, inviting them to an event, as long as it's an individual, that I think would run afoul. Because you're still trying to sell and affect your service. If that event is being used to market yourself, whatever it might be, I think that would potentially be considered a cold call. If you're inviting other businesses, business to business is not considered a cold call. It's just individual members of the public. So if Evan's a broker and he's inviting Candace, who's a broker, to an event, that's fine. That's not considered a cold call. It's really individual members of the public that would be impacted. Here's one that comes up a couple of times, unfortunately. I've seen brokers have called and said, I found out my salesperson didn't get an agency disclosure form signed. I was looking back at this transaction. What do I do? Well, brokers have a duty to supervise, right? That's in the law. Consistent and frequent personal superintendence over those associated licensees. So you need to make sure you're supervising your salesperson. You may realize they made an error, okay? And those happen, mistakes happen, right? But that doesn't mean you let it go. You have a duty to supervise. And what brokers should be doing and consider doing is you want to provide that salesperson immediate education. Document that you inform them that they did the wrong thing and what they need to do going forward. You may want to consider disciplining that salesperson depending on the circumstances. You also might want to engage in closer monitoring of their activities. You also might want to provide reminders, education to everyone in your office on agency disclosure obligations, because if one person in your office didn't do it right, there's a chance everybody is doing it the wrong way. Really what it comes down to is document you're providing adequate supervision. What's required in a particular circumstance could vary, but these are the types of things brokers need to be doing if they spot errors. They shouldn't just be, oh, okay, it happened, too bad. Make sure you are engaging in supervision. You're spotting patterns. If there are issues, you are correcting them if they can be corrected. You're documenting the error. You're informing them of the error. And again, possibly discipline depending on the circumstances, and providing opportunities to educate everyone in your office. Another question that comes up a lot is about virtually staged photos, and can you use them on the MLS? Yes, you can. You can remove items from an image. So like trash cans, cars in a driveway, furniture. You can alter furniture that's not affixed to the property, that won't remain. You can put furniture in the in an empty room. You should clearly label if you virtually staged photos. I think that provides full disclosure to anyone looking at them. But remember, all photos have to present an accurate picture of the property. So if you're going to manipulate a photo in any way that edits out flaws, cracks, changes the structural appearance, moves windows, that kind of thing, you're asking for trouble. That could violate Department of State rules. That can violate Article 12 of the Code of Ethics concerning your obligation to provide a clear picture of the property. So just make sure you're careful and you're not doing anything that would mislead a buyer as to the condition of the property, the condition of the structure, the house. It should be things that are not going to remain in the home, that can be easily changed. And again, my recommendation would be to clearly label any photo that is virtually staged. What about another question? School districts. What information can I provide regarding school districts? Hopefully, a lot of you have read our education on this. We've routinely, especially during Fair Housing Month, go over this. But for those of you that have this question, and I know it comes up, you get questions from buyers about school districts. What can you tell me about the school district? They may ask you, is this a good school district? Well, here's what you can do and what you shouldn't do. So you want to provide objective and reliable information. You want the client to make their own decisions about whether a school district is good or bad. It's not for you to provide them an opinion or subjective information about what you feel concerning a school district. You should direct buyers to third-party sources with specific school information, like the school district. Here's the school district's website. Here's the phone number for the school district. Here's information, an information sheet. A lot of the school districts even have information sheets. You can create handouts about the school district that provides information about the website, school district contacts, phone numbers. Let the client do their own research as to whether they think that school district fits their needs, is good for them, is bad for them. You're not providing any kind of opinion, because if you do, you could be engaging in what's called steering. So you don't want to express positive or negative views about not only school districts, but communities, things of that nature, because it can give the impression or actually be considered directing the buyer away or towards certain neighborhoods based on a protected characteristic. So best practice, provide the information that comes directly from the school district, from municipal sites, things of that nature, and not your own opinion. Cindy asked about niche.com. I would be careful about kind of third-party websites, especially ones that kind of report, kind of information that may be more subjective. My opinion is really provide the information that comes from the school district itself. Information about the program, whatever it might be. That there could be does this school have a music program? If you don't know, you just provide the information from the school district. I think that really is the best practice. Some of the third-party websites that provide ratings about schools, it can get a little bit, kind of a little thorny in that respect. You can certainly let them know where they can do their own research, but I would not provide them, third-party research about school districts. Question comes up a lot of times here about releases, and let's say you're representing a seller, could be representing a buyer who under an exclusive buyer representation agreement, and they want a release. They are not happy with you for whatever reason. They want to end their relationship. What do you do? Well, often the calls that come into the legal support center are from the salesperson. First thing, if you're the salesperson, you need to speak to your broker. All right. I know there's a lot that's impressed. Well, I'm the listing agent, right? You don't own the listing. Your broker owns the listing. It's the broker, not you, who owns the listing. So anytime you encounter an issue with a client and you're the salesperson, you should first consult with and take direction from your broker. That's always going to be the first thing that when you call the legal support center, if you're not the broker, I know it's always asked, whether you call NYSAR, whether you call LIBOR, have you talked to your broker? You need to speak to your broker. Your broker owns the listing. It's your broker's client. Although I know you call it your client, it's the broker's client. You do not hold, you can't operate as a salesperson unless you're working under a broker. So the ultimate decision on issues like granting a release are up to the broker. So really make sure that you're speaking to your broker if you are a salesperson. And brokers, let your salespersons know that as well. I think that's also part of your duty of supervision in terms of having that consistent communication. All right, another issue that comes up a lot, and I'm going to cover this as a separate topic, but probably the most frequently asked question through July and even into this month has been about the New York City Fair Act. So we're going to talk about this, and this deals with rentals in New York City. The Fair Act, which stands for the Fairness in Apartment Rental Expenses Act, prohibits landlords from passing the fees of brokers they hire. So the landlord's broker, they can't pass that fee to prospective tenants. This law is a New York City only law. So it applies to any rentals that are in New York City. New York City does not include Nassau and Suffolk County, believe it or not. That's a question that came into the Legal Support Center last month. But Queens, Brooklyn, all the five boroughs are considered part of New York City. And we have many members, a big chunk of our membership is in Queens, works in Queens. So it's very important. If you're a Nassau County brokerage or agent and you have a listing in Queens, this applies to that listing. It's based on where the property is located. So again, it applies to all rentals, residential rentals, doesn't apply to commercial, all residential rentals and leases in New York City. Went into effect in June. There were attempts to stop it with lawsuits. Those were not successful, so the law is in effect. It doesn't apply outside of New York State. So outside New York City, sorry. So the rest of New York State, as of now, has no such restrictions. There could be there's talk maybe next year that the state legislature might pass a similar law. But as of now, it applies only in New York City. So yeah, Joe just asked the question, are there indications this is coming to Long Island? I don't necessarily see it maybe at a county by county level. I haven't heard any talk of that. If anything, the talk has been at a statewide level. So the governor actually put a brief in the litigation where there was a challenge by NYSAR and REBNY to this law. And the New York State Governor's Office supported the city's efforts in on this law. So that to me is a sign that at a state level, it's something that could be coming. I also saw there was another question. I think it may have been answered. This recording and the slides will ultimately go up on our website under the legal update tab under legal. So might take a day or two, but you can look out for it there, and these will be up. So what does the FAIR Act say about broker fees? So it actually says that a landlord's agent, so if you represent the landlord, you cannot impose any fee at all on or collect any fee from a tenant related to the rental of residential real property, right? So there's no way around it. If the landlord's agent is charging the landlord any kind of broker fee, you are not allowed to collect it from the tenant in New York City. That's basically the gist of it. Also, any agent who publishes a listing for resident rental of residential real property, with the permission of the landlord, you can't impose any fee. So even if you don't have an exclusive listing, right? Let's say you have there's an open listing. Landlord says, well, I'm not going to give you an exclusive, but yeah, you can advertise this rental for me. Others might be able to do it as well. You cannot pass along whatever fee that the landlord is going to pay you, can't be passed along to the tenant, period. Really, it's it. You see that hand with the line through it? Landlord's agent can't collect from or impose any fee on the tenant. You have to have a compensation agreement, and you should be receiving, if you're going to get paid, you have to be paid by the landlord if you're representing the landlord. So you also, if you are a broker's agent, you're marketing on behalf of the listing broker, same thing. You cannot collect the fee from the tenant, period. No ways around it, no co-broke restrictions. So a tenant's agent can't say, hey, I'll share my compensation that came from the tenant with you as the landlord's agent. Can't happen. It's got to be said. If you're representing the landlord has to pay the landlord's agent. And I'll get to it in a minute. If you're representing the tenant, you can collect from the tenant. So here we go, tenant's agent. So if you're representing a tenant, tenant's brokers, you can collect a fee from the tenant if you're hired by the tenant and acting in the best interest of the tenant. So if you're working with a tenant and whether it's an exclusive, non-exclusive, you want a written agreement with that tenant. I'm saying the services I'm providing you, I'm helping you, Mr. or Mrs. Tenant, try to find an apartment. And you're gonna compensate me as follows, whatever it might be for those services. But you should have a written agreement with the tenant explaining what services you're providing, and what the compensation would be. But you cannot get paid if you're working for the landlord. The tenant can't pay you for the services you're providing the landlord. I think it's pretty self-explanatory. I know we've gotten a lot of questions. I think most of the questions that have come in have been people that really didn't know about the law. And we've put up a lot of information. You can check lirealtor.com. really, we put a video out, a lot of flyer, a lot of, really basic explanations on this. So if you're in an office that handles rentals in the city, make sure that you circulate that information. Look, in dual agency, this is another question that has come up, right? So let's say you're representing the landlord, and a tenant comes in to view the property, and the tenant also feels that they need representation and they want you to also represent them. Well, you can, if you have informed consent from both parties to dual agency, both the landlord and the tenant agree. They are explained the risks of dual agency. They sign off on the agency disclosure form allowing for dual agency. They agree based on informed consent to dual agency. You can receive your compensation for the listing side from the landlord, and you could receive compensation from the tenant for the services you are being paid by the tenant. But again, the landlord's fee, whatever the fee to list the property, cannot be paid by the tenant. And if you're going to be paid those separate fees by both, you need consent from the landlord, consent from the tenant. Um, what if I see a question from Tiffany? What if you are not the listing agent, have a tenant, but represent the landlord? So I think that what you're saying, you're either then a broker's agent possibly, or it's an open listing. Again, if you're working or advertising a property on behalf of the landlord and you're not representing the tenant, you cannot get compensated by the tenant. The only time you should be getting compensated by the tenant is if you have a written agreement with that tenant and you're providing services to that tenant as a tenant's agency, either alone or as an authorized dual agent. And in that instance, again, you're only getting paid by the tenant for the services you are providing to that tenant. The law also has fee disclosure requirements, so every listing has to disclose any tenant fees to be charged in execution with the lease. And also before signing the lease, the landlord or their agent has to provide the tenant with an itemized written disclosure of all fees, including a short description of each fee. Disclosure has to be signed by the tenant prior to signing a lease, retained for 3 years, and a copy must be given to the tenant. There's significant penalties here. It can be enforced by the Department of Consumer and Worker Protection. There's also the ability for individuals to bring a civil action, what's called a private right of action. So even if the city doesn't get you, a tenant can bring their own lawsuit against you directly. Department of State has also said that they will discipline, whether it's fine, licensure issues, if someone is found to have violated this law. Even though it's a city law, Department of State can still subject you to licensure penalties if you are found to have broken the law. So significant penalties if you do not comply with the law. A couple questions on this. So, can the landlord, have the tenant, in lieu of things, pay the first month of rent to the listing agent? Let's say we structure it that way. No, there's no workarounds. Again, the tenant cannot pay any fee to the landlord's agent. So whether it's structured as a rent payment going to the landlord's agent, it's just not permitted. This is the key language. Landlord's agent, and I'll say landlord's agent, really anyone working for the landlord, whether it's an open listing, but a landlord's agent shall not impose any fee or collect any fee from a tenant related to the rental of residential real property. That's it. This question's also come up, and I unfortunately can't give you a definitive answer, but what's the impact on accepting a broker fee from a voucher program? So, in that instance, the payment's not coming from the tenant, right? It's coming from a voucher program. So let's say you're the landlord's agent, and you're listing this property. The tenant who's accepted is paying through a voucher program. Can the voucher program pay the listing broker a fee? I say it's not clear yet, but remember, the law says you can't impose a fee or collect a fee from the tenant. So I could see a court saying, well, it's really the voucher's paying on behalf of the tenant. So in sum and substance, it's coming from the tenant. My guidance at this point is one, never ask the tenant for any fee if you're the landlord's agent or working for the landlord. Never demand that their voucher program pay a fee. If the program does offer to pay the fee, and they feel they're permitted to do so, you would want to get the program to acknowledge that in writing and document that in writing. We've been trying to get guidance from these different voucher programs on how they intend to address this. But that third bullet to me is really important. Just make sure you shouldn't, if you're representing the landlord, whether it's through a voucher program or from the tenant, you cannot demand that the tenant pay any fee for the services that you are providing to the landlord. I see a couple other questions about this. I don't want to take up too much time on the Fair Act. So what I'll do is if there are additional questions on this, we can cover them, at the end. What about tenants agents splitting a commission with the landlord's agent? Well, this has really been covered. The tenant, you're not allowed to do that. The tenant's agent the landlord's agent has to be paid by the landlord. The scenario above, which I think I even covered in an earlier slide, this would be the tenant paying the landlord's agent through the tenant's agent. It's just really not that different than through a voucher program. It's just don't try to find workarounds. I say this with every law that comes out. Workarounds 99.9% of the time are going to get you in trouble. All right, I'm going to move to another topic, and this one covers everybody. We're talking statewide now, and this is the New York State Property Condition Disclosure Statement. Just want to let everybody know there is a new property condition disclosure statement form. It's not a big change, but the form was updated on July 1st. So make sure that when you are providing the form to your sellers, that they are getting the correct form, because you do have an obligation to inform the seller of their obligation to complete the form. And when you do that, when you take the listing, I'd recommend that you also provide them with the form. And you want to make sure you're providing them with the correct form, which is the version that went into effect in July. Not a big change, but there was a new instruction added under question 36, which deals with sewage systems. It's just a minor change. It includes reference to the Department of Health website for septic system operation. And really, this is the new language that was added. From a substantive standpoint, I don't think it really makes a huge difference, but certainly the state felt it necessary to add this disclosure language in the property condition disclosure statement. And you are required to make sure that you're giving the correct form to a seller. So please make sure you're providing that. The new form, it's on the Department of State's website. It's on LIBOR's Documents on Demand page. So if you don't have it, make sure that you've uploaded that document, and that is the one that you are using with your sellers. You do have with respect to the property condition disclosure statement, your remaining obligations haven't changed. What your duties are, well, if you're the listing broker, your listing agent, you have to timely inform the seller of their obligations under the law. That's basically what the law says. So how do you do that? You're going to give them the form when you take the listing. The LIBOR form listing agreement has a disclosure in there. We also have additional forms that you can use when you provide the property condition disclosure statement to let the seller know that they have an obligation to complete that form and provide it to a buyer prior to the buyer signing a contract. And you do also have an obligation if you represent the buyer or if you're a seller's agent dealing with a prospective buyer as a customer. So you want to, and you have to, before the buyer signs a contract, let them know what their rights and obligations are under the law, which are effectively, you've got the right to receive this form and review it prior to the time you sign the contract. You have no other obligations. The seller is the one that has to complete the form. The seller has to deliver it to the buyer before signing a contract. That's the deadline by which they have to deliver it. Many sellers, they want to provide it sooner. It might be a good thing to provide it to facilitate a deal. I know many buyers want the property condition disclosure statement before they do their home inspection, and that's a completely reasonable request. But legally, the seller does not have to provide it until just before the buyer signs a contract of sale. No legal right to get it sooner. Um, just remember, this was a change from last year. There's no longer the option of a $500 credit to buyers at closing. Um, but there are some attorneys. I know we've been trying to put out a lot of education. I've heard some of you have told me you've seen it in contracts. Attorneys are still putting in the $500 credit. They should not be. It's not allowed anymore. There is a requirement that the form needs to be completed and signed by both parties, and it is to be attached to the contract of sale. Let me just see. I need um, Tiffany has a question. The bottom of the new form say July 1st. That's the date it went into effect, Tiffany. I don't remember off the top of my head what the revised date that Department of State used on the form. The form that's on Documents on Demand is the most up-to-date version. July 1st is when it went into effect. I think it may have either like a May or June 2025 on the bottom. Again, this is a form that the state puts out, State Department of State, but the form that's on Documents on Demand and on the Department of State website is the most current form. But I think you're correct. I don't believe they put the revised date as July 1st. That was just the date that new form needed to be used. Remember just who he needs to complete. It's a seller of residential real property, and residential real property is 1 to 4 family dwellings. It doesn't include vacant land, condos, or co-ops. And we went over this already. There are a number of exceptions that are out there. Big ones being bank-owned properties, court-ordered sales, fiduciary sales, and new construction. All right, so a new topic I want to just go over with all of you, and I'm going to do this in like 5 minutes, and I could probably do an hour on this. But this is just to sort of put in your head an issue that is out there that I could see being um, a trouble spot in the future, and something that I think everybody should just make sure that they have familiarity with and are complying with, and that's called RESPA. It's a federal law. It is the Real Estate Settlement Procedures Act. And why am I talking about it? So there was a new lawsuit. It was in North Carolina. It was filed, I think, the end of July. Hit some of the bigger real estate news outlets in the beginning of August. And it was a lawsuit by individuals. It's not a government lawsuit. It was a lawsuit by individuals, home sellers, against a North Carolina brokerage. And it said, hey, you steered us to a mortgage lender that basically cost us more money. And we had to pay more. And I think some of them defaulted on their loans. And effectively, we never would have picked this lender, but for your kind of pushing us that way. Oh, and by the way, we've discovered that this lender paid for half of your digital marketing costs. And those marketing costs really were to market you, not the lender. So you were really getting a kickback from this lender, and that violates RESPA, and we're suing you. And you know what? Under the reason I'm bringing this up is because RESPA is a law that the federal government can enforce. And I know there's been a lot of talk in the media. Federal government may not be as active in enforcing some of these consumer protection laws, but this is also a law that individuals can file a lawsuit under in what's known as a private right of action. So class action lawsuits can be brought under RESPA. So plaintiffs' attorneys who are looking for a payday and looking to find the next big thing can potentially use RESPA as a way to go after real estate brokers and settlement service providers. So it's something that everyone should be aware of and make sure that you are complying with. And the big area I'll talk about where compliance can kind of become an issue is with marketing. So the whole purpose of RESPA, they want to protect home buyers from hidden fees. and prohibit illegal referrals. Um, and really the uptick of the law is you have to fully disclose if you have an affiliated business relationship or arrangement where your brokerage owns any percentage in a related business. And also, you can't receive payments or gifts in exchange for referring clients to other settlement service providers. So, who are settlement service providers? It's a whole, basically anybody who's going to offer services to help finalize a real estate transaction. So that's all you, right? You're all settlement service providers, but it's a whole litany of other folks out there in the industry that you probably work with and you may market yourself with, right? So it's title companies, mortgage lenders, appraisers, it's home inspectors, attorneys, homeowners insurance providers. It's really anybody who's involved up to the point of closing in a potential transaction. So there's a part of RESPA that says settlement service providers can't give or receive things of value to each other in exchange for referrals. And things of value doesn't just mean, money. It's really anything. And that's where RESPA can lead to issues. Certainly, you can exchange money with each other if it's for actual goods or services, right? And it's not tied to referrals. But if there's any exchange of money or things of value that fall outside of that exception, it can be a problem. So where the big problem is in these co-marketing and marketing services agreements. So I give you this example, right? Let's say you're a broker, and there's a title company, and you're like, we're going to market ourselves together. We're going to put, signs up all over town saying, we're a great team, right? But the signs that go up really only talk about your brokerage. They don't mention that title company or that insurance company. But you've agreed to split the cost of that marketing 50-50. That can be viewed as an illegal kickback because that title company, that insurance company, whoever it is that's advertising with you, they're paying for something that benefits you, but they're not getting an equal benefit. So anytime you have these types of joint marketing agreements, you want to make sure that whoever's paying what is reflective of the amount of advertising they're getting. I think hopefully that makes sense. The issue becomes if one party's paying more into that pot for advertising and they're not getting anything out of it, the government or even a plaintiff's attorney is going to say, hey, that's an illegal kickback. Basically, it's a referral fee. You're finding another way to pay money to that broker for referrals, but you're not calling it a referral fee. And that's where things can get thorny. So what should you do to avoid? And these are just some quick hitters. Again, if you've got follow-up questions on this, we just did a legal tip on this that has a whole host of resources to check out. I would really encourage you, if you're a broker and you have any kind of joint marketing agreements, to take a closer look at this. But best practices are, one, never accept payments for referrals from other settlement service providers. Two, if you're going to recommend other settlement service providers, do it correctly. Have a list of multiple vendors. You always want to include a disclaimer that lets it to, it's the consumer's choice to make. I often recommend the rule of three. When I was a practicing attorney on the real estate side, before I came here to LIBOR, people would ask for home inspector recommendations. And as a settlement service provider, I was always careful. I said, well, here's three, or sometimes depending on where the property was, maybe two, sometimes four, but I would give them a list and include some kind of disclaimer that left the choice to the consumer. If you have co-marketing agreements and you're splitting costs, just make sure the cost is proportioned to who's getting what in terms of the advertising. If you're an agent, you should not be entering into these co-marketing agreements without your broker's approval. Your broker is the one who makes decisions about advertising. And also, if you're a broker, make sure you review these types of agreements with your attorney. It's very important. I can't stress enough. I just see this being a potential pitfall down the road. And certainly, if you have any kind of affiliated business entity, so you have an ownership stake of 1% or more in some kind of settlement service company, so it's a title agency, whatever it might be, you have to disclose that in writing to your clients or consumers. You have to let them know in writing they're not required to use that business. And any payment for the referral, it can't be for the referral. It has to be related to a return on the ownership interest. So a lot more. I really went over this quickly. It's just to highlight the issue. And if you have other concerns, other questions, please take a look at the website. And again, if you're a broker, make sure you consult with your attorney on these things. Last two topics I want to hit, because this is another area that we get a lot of calls on to the Legal Support Center, and that is lawful source of income questions. And I continue to stress this in every class I teach, that lawful source of income is a protected class in New York State. And that does not mean that you can't ask about income. You absolutely can. Housing providers can ask someone, what is your income? They can ask where it comes from. What is your source of income? And they could ask you for proof. I want to know, do you have the ability to pay for the housing? And this is really comes out in usually rentals. But does this tenant have income? Where does it come from? And can they afford to pay? That's fine. You can ask all of those things. The issue comes down to accepting all sources equally. That's the issue. I cannot favor one source over another. I can't say Evan's a better tenant than Candace because Evan gets his money from a job at XYZ company and Candace gets her money from a job at another company or from Social Security or whatever it might be. You can't do that. You have to accept all lawful sources equally. You can't discriminate on the basis of where the money comes from. I see a question. Sultan says, two questions. One about the referrals. Yeah, I would recommend 3 options of names. I think that's best. That's going back to the prior topic. And he asks, as a licensee, can I say I don't do rentals? Yes, if that is the case, and that is your response to every single person that calls. You must be consistent and provide equal services to all. So if you are a broker or an agent who does not handle rentals, keep it that way. Don't suddenly say, well, if somebody calls and they say, well, I'm interested in finding an apartment for $20,000 a month, can you help me? Oh, yeah, sure, I can help you with that. But then, for the last month, you've called every other person that's called saying either that they had a voucher or anything else. Oh, I don't handle rentals. You can't pick and choose. So if you are someone that doesn't work, and there are plenty of licensees out there that don't work with rentals, and that might be a smart decision if you're not familiar with the rental landscape. But you want to make sure that you are providing the same answer consistently to everyone that calls if that is the case. Back to lawful source of income, it really includes everything. It's any kind of lawful source of income. And the big area that we see discrimination and problems with comes with vouchers. Vouchers are a lawful source of income. That seems to be where confusion comes up. And I'm not making up that there's been confusion. Here's just a couple of reported cases brought against real estate licensees, apartment complexes for violating the law and saying such things as, this owner doesn't participate in Section 8, or I have to find out, or this apartment complex has reached their limit, reached their quota. I have to get back to you. All of that is considered discrimination. If a landlord is working with you as a real estate licensee, they must accept all lawful sources of income. That doesn't mean they have to accept a voucher for $1,500 when the rent is $4,000, right? That's somebody wouldn't have sufficient income. But they can't say, well, this person has a voucher that covers the rent, and I really don't want to work with voucher holders because for whatever reason. That is discrimination. That is the problem. And here's all the examples of what looks like and is source of income discrimination. I can't say, oh, this apartment doesn't take vouchers. Or you can't say, I only work with landlords who, I don't work with landlords who take vouchers. You as a real estate licensee have an obligation to work with landlords who take vouchers. If a landlord does not want to take a voucher, you should not be working with them, period. That's it. You tell them, I can't do that and I can't work with you. All right. So, tips to avoid lawful source of income discrimination. Look, it's very simple. It's just like any other protected class. You don't turn away a prospect because of their race, religion, national origin, color, right? Same thing. You don't turn away prospects because they receive some kind of financial assistance. You tell prospects about all the vacancies that meet their needs, period. So you have a standard operating procedure with every single tenant. It doesn't matter that they get a voucher. If someone calls up, you should have a standard set of questions such as, what area are you looking in? How many bedrooms are you looking for? What's your price range? Not, do you have a voucher? It's no if somebody says they have a voucher, you still ask these same questions. Okay, great. What area are you looking for? How many bedrooms are you looking for? What's your price range? So you're going to show voucher holders the same apartments you would any other prospective tenant, regardless of their source of income. You do want to maybe, in the case of somebody telling you they have a voucher, you're going to want to get information about their program, their caseworker, copy of their voucher, educate yourself to the details of their program, period. It's not that difficult. You just need to train yourself to have a process and follow that process. We went over this. If somebody you're working with, an owner, says, I'm not accepting vouchers, just cut them off, end the relationship, walk away. It's not worth the trouble. It's not worth the potential licensing loss or significant fine. You advise the owner that I cannot refuse to work with voucher holders and I need to stop working with you, and you document the termination of your relationship. It would be no different than a landlord telling you, I'm not going to work with these people, meaning color, race, religion, national origin, whatever it is, gender. You can't do it. It's discrimination. Don't do it. Walk away. It's not the minimal commission you're going to get out of that is not worth the risk of losing your license, period. Last topic on this comes up a lot. What about credit scores or credit checks or income requirements? A landlord wants to require that. Yes, they can require it, right? They can advertise that they require it, but if the voucher covers 100% of the rent, so it's a $2,500 a month apartment and someone comes with a voucher for $2,500, the landlord can't require a credit check or reject the tenant based on negative credit history. If the voucher covers a portion of the rent, credit can be considered on a case-by-case basis, but just remember, requiring a minimum credit score can still violate the law, because if no one with a voucher would ever be able to meet that requirement, that would be discriminating against anybody that had a voucher. And also, you should talk to the voucher program. Most of these programs, even if they've qualified somebody for less than what the rent is, they've already done the analysis and determined that whatever additional income the individual has can cover up to a certain amount, can cover whether it's utilities, something else. So there's no need at that point to apply any other factors. And if a landlord does, and those factors would disqualify anyone who has a voucher, that then can result in a claim of discrimination. So please take a look at that. Last topic, I've got about 2 minutes left. Please look at the handouts that I included with today's class. It's just some guidance from Department of State on advertising. Department of State's always looking at advertising. Every month they're fining licensees for advertising violations. The number one thing you can do, if you look at that second to last bullet, it's something called the advertising checklist. It's one of the handouts that I gave you, comes right from Department of State. That's what they use when they look at your advertising. So there's 2 times they'll look at your advertising. They do random checks, but also if anyone makes a complaint against you ever for any reason, they are going to wind up, looking at your advertising. So look at that checklist. Make sure that you look at everything like your business card, and I'll put these slides up when we post the video, just kind of some information on what you can do to avoid easy fixes to avoid fines. Do your own audit. Make sure that you're checking your own advertising periodically. Last thing I just want to let you all know about, please, please, please if you're going to use photos that you didn't take in any capacity, you're potentially asking for trouble. You should never publish photos that you didn't take or you don't have written permission to use. So photos that didn't come from a photographer that you hired. If you do, you could be liable for copyright infringement, significant damages. Don't use someone else's listing photos to promote yourself as the buyer's agent. Take your own photo. It can lead to copyright infringement problems unless you've taken the photo or have written permission to use a third party's photo. You're probably violating someone's copyright and you could be on the hook for substantial damages. So just make sure that you don't, I know it's tempting. It's so easy to right click or take a screenshot and make a really cool graphic. Don't do it. It's illegal and you could be putting yourself in significant danger. All right, so that covers what I wanted to cover today. I think Evan already put the poll up. So, Evan, if you want to just let everybody know what they need to do to grab their credit. Thank you, everybody, for your time. And I will stick around if there are any other questions.